Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Hello, and welcome to another episode of the FIA Group podcast, Empowering Plans. My name is Kelly Dempsey, and I'm here with Kevin Brady. We are two attorneys that work in the consulting department here at FIA, so we address questions all day, every day from our clients. And one of the most hot topics right now is the Biden vaccine mandate, which is requiring OSHA to come out with rules regarding that. So the rules were recently issued, and we're going to kind of dive into what this emergency temporary standard rule is and what the requirements are and a lot of the questions we're getting. As you can imagine, we're getting a ton of questions because of what was happening last week, and there's obviously a lot of court challenges. So I'm going to start with an open disclaimer that by the time this is actually published, things may be changing, especially related to the current legal challenges and what's happening. So we are operating based on the information we have today, right now, and things are definitely going to progress very quickly here. So it's likely that some of this information may be a little outdated by the time you hear it, but we're going to give you the rules as we know them right now and kind of go over everything. So as you may recall, back a couple months ago, I think September 9th is when President Biden announced the broad vaccine requirements and the concept of having a vaccine mandate. So these mandates are going to be applicable to federal workers, healthcare workers, and certain private employers that meet certain size thresholds. So the goal ultimately is to increase the vaccination rate. That was the main reason behind this. Obviously, there's been various variants of the COVID-19 virus. Therefore, the goal is to try to get as many people vaccinated as possible. That's always kind of been the underlying theme. So this new mandate is expected to impact 84 million American workers, which is approximately 2/3 of the American workforce. So it has a pretty big impact, pretty broad sweeping impact to a lot of employers. And we're definitely getting questions from our clients already about what plans need to do and the payment from the plan versus the employer versus employees. So we're going to try to dig into as much as we can, knowing that we only have a short time together. So with that, I will turn it over to Kevin to talk about the emergency temporary standard rule that was issued by OSHA last week.
Yep. Thank you so much, Kelly. So obviously, as Kelly mentioned here, last week on November 5th, the Occupational Safety and Health Administration, OSHA, issued an emergency temporary standard rule, which essentially requires employers to implement vaccine and or testing requirements in the workplace. So this rule applies to employers with 100 or more employees. So as Kelly said, not all employers are necessarily subject to this. It's going to be limited to those employers that have 100 or more employees. Furthermore, the rule requires essentially employers that are covered, meaning that they have 100 or more employees there, to adopt a written policy to either basically implement a mandatory COVID-19 vaccination policy or implement a requirement that employees submit to weekly testing and use face masks while in the workplace. These requirements go into effect very quickly, and employers will have to implement these policies in quite the short order. For example, by December 6th, so just right around the corner in a couple weeks here, employers must develop and implement these policies, basically have them written down, put the policies and procedures in place so that they can enforce both, vaccination mandates and or, the weekly testing requirements there. So, basically having these written policies, written down, put on paper so that they're in a good position when the time comes to actually start to enforce these policies. Like I said, this is, kind of the first step here being December 6th. Moving forward, by January 4th, the employees that would be subject to any vaccination requirements must then be fully vaccinated. So the idea here being January 4th is that it comes 60 days after publication in the Federal Register of the Emergency Temporary Standard Rule. And this time frame provides enough time for employees to go through the full vaccination cycle, obviously depending on what type of vaccine they do end up getting. Furthermore, at that point, January 4th, employers must begin weekly testing of unvaccinated employees as a condition of entering into the workplace. Finally, basically on a go forward basis, employers must be kind of in a position from January 4th on to basically enforce these requirements on all new employees to be vaccinated as soon as practicable, or from there to submit to the weekly testing requirements. So with that, just to go over a couple other important aspects of this rule, I'll toss it back over to Kelly.
So yeah, a lot going on with this rule. It's going to have a big impact. And while it doesn't necessarily, this rule obviously impacts FIA as an employer, and it doesn't necessarily specifically impact health benefit plans. This obviously is an employer-based rule. So there's a little bit of a blurred line here, and we're obviously talking about it because at a certain extent, there are questions related to the health plan. We've gotten plenty of them. So we'll get into that a little bit. But other important aspects of this rule that have come up, it's not really any different than previously discussed. Many employers are already doing this, but employers must provide paid time off for individuals to get vaccinated and recover from the vaccine. Similar to how COVID impacts individuals, there's a wide range of the impact of the vaccination. Some people are very much, ill from it for a day or two. Others are a little bit more lucky and don't have huge side effects. But the PTO requirement for individuals to take the time off to get vaccinated and recover from the vaccination is required. Again, I think a lot of employers were already doing this for their staff, so hopefully that's not too much of a shell shock. The next piece of this is that OSHA indicates in the rules that this rule preempts any existing state or local laws that attempt to limit employers' ability to vaccinate. And I guess when I say existing or, newly issued or things of that nature. So there's definitely certain states that have filed rules and requirements saying that they don't want to enforce this OSHA rule. So they've come up with their own set of rules, but rules from OSHA have indicated that those state laws are preempted. So that is not the end of the challenge, and we'll get to that at some point in a couple minutes. But while we're going over the rule, it's important to note here that this rule essentially, kind of similar to ERISA, provides a floor and not a ceiling. So employers are always welcome to do more than what the rule requires. So that's not necessarily a bad thing. So it's a minimum standard rule, and employers can go further. They can also, do things to, have individuals get vaccinated. So, for example, employers are definitely able to issue a vaccine mandate for their employees. They're required to have their own policies. They can have a policy that requires more testing than what this OSHA policy does. They can require individuals to wear masks at work, regardless of vaccination status. There's a lot of flexibility here for what employers are allowed to do. So it's more of a, here's what the rule is, implement it, and at least follow the rule at a bare minimum, and then put up whatever other guardrails and guidelines you want to do. So they're definitely allowed to have those requirements. And it's also, important to note that along with all of these is that there are still those exceptions for medical purposes and, closely held religious beliefs. There are still those exemptions from the vaccine mandate. So those were rules that were issued by the EEOC, and those still come into play here. So employers need to have that reasonable accommodation for individuals that have a medical reason for not being able to be vaccinated, or they have some sort of closely held religious belief against the vaccination. So those are definitely things that still need to be considered when implementing this rule. So take that into consideration as well. This rule will not apply to employees that are full-time remote workers, whether or not they're in their homes or if there's some other work site where there's no other coworkers present or customers present. It also doesn't necessarily apply to individuals that work exclusively outdoors. For example, like landscapers, people working at, a ski lift where they're operating the ski lift outside, things of that nature. It doesn't necessarily apply to these outdoor individuals. And I'm not really sure why I'm thinking of skiing right now, considering it's actually, 60 degrees and warm in Cleveland, Ohio today, which is nice. But, to use ourselves as an example, Kevin and myself are both remote employees. We do not work in our headquartered office at FIA. So technically, they don't have to apply this rule to us because we're both full-time remote workers. With that said, a lot of employers have gone back in the last couple of months to a hybrid work schedule. And that is one of the things that FIA has done overall with our staff. For individuals that are located in Massachusetts close to our office, we have created a hybrid work schedule. So if you are in a hybrid work schedule where you're working from home for some days or working in the office, you are subject to this rule and will still need to comply. So it's important to remember those things. So with that, we're going to go back to Kevin and talk about the testing options and how, employers are supposed to kind of put these testing rules in place. And most importantly, kind of talk a little bit about who is bearing the cost of testing, which is obviously a question we've gotten a lot.
Exactly. So for those employees who are, going to go the route of the testing rather than, the required vaccination, anything like that, there's obviously, a little bit more detail and rules surrounding that aspect. First and foremost, employers must require all those unvaccinated employees to continue to wear face coverings when indoors. As Kelly kind of mentioned, this doesn't necessarily apply to vaccinated employees. Obviously, employers have discretion on whether or not they want to, incorporate that type of requirement on their vaccinated employees, and, local and state regulations might be involved there as well. But at the end of the day, if an employee is going to opt into the testing option rather than the vaccination, those individuals are going to be required to continue to wear face masks while indoors. And then another aspect of this too is that OSHA provides, a decent amount of detail surrounding what those COVID-19 testing requirements are. So, first and foremost, the first thing to think about is that the test must be, either approved by the FDA or authorized under emergency use authorization. And this is going to be similar to, the kind of test that we've seen from a health plan perspective when we're looking at COVID-19 tests. Obviously, there are a lot of tests out there, some at-home tests or whatever it might be, and not all of them are necessarily going to meet the threshold required under the OSHA rule. The second requirement is that it must be administered in accordance with the authorized instructions. So like I said, there are a number of different tests out there. Each of them has their own kind of procedures that go along with going through the test and administering it in an effective way. And it must be done, obviously in that fashion. And the third thing that I found to be quite interesting is that the test cannot be both self-administered and self-read unless it is observed by an employer or an authorized telehealth proctor. So for this, the common thing I think about is, doing an at-home test where you're swabbing your own nose or anything like that, then you're reading the results on your own. That's not going to necessarily meet the standards required by the OSHA rule. Here, it's either going to have to be, whether it's in the presence of an employer or a telehealth proctor who's, on a video screen watching you do the test and helping you read the results. That's going to be what the requirement is. And, really the idea here, whether it's to prevent, proctoring or anything like that, for me, I've done a couple at-home tests myself, and I got to be honest, they're not always the easiest things to kind of administer and understand the results of what you're reading. But the goal here, obviously, is to prevent, people from going into the workplace, thinking that they might not be infected or, exposed or anything like that, and make sure that, the administration, the reading of the tests is done in an effective and obviously the correct manner. So like Kelly mentioned a couple of times here, and I think it is very important detail here, is kind of thinking about, who bears the cost of testing. So we have a lot of players in the game here where we have employers, we have employees, we have health plans, and, sometimes looking at, the details of what might be going on is really important to understand who should bear the cost of that test. So, first we'll look under the OSHA rules. So under this emergency temporary standard rule, the testing is not going to be necessarily required to be covered by an employer. Employers do have discretion to pass the cost of those tests onto their employees. Of course, employers have the option to pay for testing if they want to. It's perfectly within their abilities to pay for any type of test or anything like that, but it is important to note that employers do have the discretion to pass that testing cost down to the employee who's taking the test. The second kind of bucket to look at would be, the health plan. So, with the health plan, the requirements under the FFCRA and the CARES Act are still in effect. So, what those are looking at is, the medical appropriateness of the situation for that individual. So whether it be, an individual is experiencing symptoms of COVID-19 or a possible exposure or anything like that, then that's really what's going to trigger, a health plan's requirement to cover the cost of those tests. The big difference between, a health plan's requirement versus, an employer or anything like that, you really do have to look at it in two buckets. So, with the OSHA rules, that's what we'd call surveillance testing, where, there's maybe not any, medical reason, for that individual specifically to get a test other than to make sure that they're safe to go into a workplace. Whereas with the health plan, there's some reason, a medical professional, somebody's looking at the situation and determining that that individual does have a need for a test for COVID-19. So those are really like the two buckets that you'd look at. The situation does get even more complicated, if you think about an employee that is exposed at work. So if you could trace, potential exposure to COVID-19 to the workplace or anything like that, that's not really something that's going to be, considered under the OSHA rules. That's going to be, something that we'd look at under the health plan requirements. And, really, like I said earlier, the medical appropriateness of the situation. And the reason that it becomes more complicated, obviously, is because that could also be, potentially a workers' compensation claim. And at that point, really, it does come down to, a fact-intensive, look at the situation to see, is this workers' compensation? What state are we in? How does this state treat, these types of claims? And then from there, try to make a decision, whether it's from coordination of benefits perspective or subrogation, to determine who the proper payer is. But it's definitely interesting. It's an interesting kind of consideration on, who bears the cost, when does it happen, and things like that. So something to keep an eye on. I'm sure there might be, issues moving forward. There's a lot of different moving pieces, and trying to keep those straight is not always the easiest thing. But yeah, with that, I'll toss it back to Kelly, talk a little bit about penalties, and then obviously the looming beast of potential legal challenges to the ETS rule.
Thanks, Kevin. I think it's definitely important to note that when it comes to the cost of testing and how employers are setting things up and whether or not it's the health plan or workers' comp that are involved, it's always going to be a case-by-case determination when deciding what needs to happen and where. So we have to separate out the concepts of this testing of, other testing that might be happening if somebody has been exposed. So the basis of the reason for the testing is obviously going to hopefully help guide and dictate who needs to pay or what needs to pay based on whatever rules the employer puts in place. based on this. So there's still the health plan requirements at the end of the day, but there's also these new, obviously for these additional tests that are going to be administered for non-vaccinated employees. It's definitely going to have to be broken down and piece by piece and based on the facts and circumstances. So definitely very interesting. When it comes to penalties, I'll be the scary lawyer that throws this out there that there's a current cap on the violation. So a serious violation is capped at a very odd number of 13,653. And then there's much larger penalty for willful or repeated violations. That's 136,532. So there's definitely some big random numbers here, but the most important takeaway here is that the rules have indicated that OSHA is authorized to issue separate penalties for each instance of noncompliance. So this is kind of similar to, the ACA rules that if a non-grandfather health plan doesn't cover a preventive care service, the penalties are $100 per day per impacted individual. So say a plan doesn't cover the measles, mumps, and rubella vaccine, the MMR vaccine. If there are, 15 people on the plan that tried to get that vaccine, those penalties will accrue for those specific individuals until the issue is corrected. So this is another situation where the penalties are going to keep accruing for as long as the employer is not in compliance. So it's very important to remember that. And again, there's definitely multiple layers here when there is a violation, which rules are being impacted and determining whether or not there is some sort of other penalties. So definitely important to remember. So when I say if the employer doesn't cover the vaccine specifically under the preventive care rules and it's a non-grandfather plan, then you've got the ACA penalties plus potentially other penalties if you aren't following these rules. So the penalties can compound and will apply depending on what the fact specific situation is. So very much important to know separate penalties for each instance of non-compliance. So it's very important that when an employer does this and puts together a policy in place, they're doing it from start to finish and not piecemealing things together. With that said, we all know that there has been a lot of talk and unrest regarding legal challenges to this. And there's a vast amount, and I'm not even going to set a number at this point because I've lost track of the number of challenges that have already arisen over the weekend when these rules were issued on the 4th, which was only, not even 4 or 5 days ago. So there's a bunch of court cases that have been filed. And the most prominent one was issued in the 5th Circuit, which is Texas, Louisiana, and Mississippi. And I only know that because I have a chart behind me, but that is where the 5th Circuit is. So notably, this is the same circuit that had original challenges to the ACA. So that is the first one that happened, and there was an expected response yesterday. We have not heard just yet. Kevin and I have been Googling all morning trying to find an update on this, but haven't seen one yet. All we know is that there have definitely been additional circuit court cases that are filed in various federal circuits. So I believe the most recent one today was in the 7th Circuit, which is Wisconsin, Illinois, and Indiana. So again, these lawsuits are popping up as part of the 5th Circuit. There were a couple of states that aren't actually in the 5th Circuit that were part of that lawsuit. I think South Carolina joined in that one, and they're not in the 5th Circuit. So lots of states in unrest, notably that many of the states that have filed challenges are those that have either Republican governors or Republican attorney generals. So again, not necessarily a surprise. But one of the things that Kevin and I learned today, because this was interesting, that with all of these conflicts, we were wondering, how does the court decide where this goes and how these proceed? Because obviously there's a lot of lawsuits filed that all have the same common goal, is to stop this mandate from being imposed. And normally when a federal circuit court blocks a rule, usually it's done at a nationwide level, but the block that was put in place yesterday didn't necessarily clarify if the rule was just being blocked from those states that were involved in that lawsuit or if it was applying on a national level. So that's still kind of an unanswered question. But again, now that there's multiple circuit courts that are impacted, this obviously is going to need to be addressed sooner rather than later. So the thing that Kevin and I learned today is that there is a process that was created by Congress for when there are OSHA standards, like this emergency temporary standard. And what happens if there are all these multiple lawsuits is that the judicial panel on multidistrict litigation will essentially randomly designate one circuit from where all the lawsuits are filed within 10 days of when OSHA issued the emergency temporary standard, and that all courts will have to transfer their proceedings to that one specific court. So it appears that there's essentially going to be a lottery to decide where this case is heard. And that's really important. And I know that I'm not usually the one that talks about this stuff or gets excited. It's usually Brady's thing. But, it is interesting to see when there's this many challenges, how it's going to end up, because where it ends up is very important. But at the end of the day, it could end up in front of the Supreme Court as well, depending on what happens at the circuit court level. So we're yet to know if the stay is in place for just those individuals in those areas or if it's a nationwide. So at this point in time, the recommendation would be for employers to get all their policies and procedures in place, start putting their plans together for those implementation dates that Kevin talked about. So, that would be the December 5th date and the January 4th date of 2022 to make sure that all these policies are in place so that if the rule does go forward, you're ready for it. Because, that is the lawyerly consultative thoughts here, is that it's not good to, wait until the last minute to try to put together this, because these are going to be complicated and it's going to involve obviously a lot of individuals if this is applying to employers with 100 or more employees. So start putting your policies and procedures into place, figure out how you're going to implement things, what your policies are going to do, if you're going to have to provide proof of vaccination or the weekly testing and accepted face coverings, in the office. Start putting all of those things together so that when the rule, truly does go into effect and these timelines are hit, you're ready. Because things, obviously, as we know, can hopefully play out very quickly in court, but it can also take a long time to get a rule pushed all the way through and the challenges all the way through, especially when they are complicated. So obviously the arguments from the government at this point are that OSHA acted within their authority to issue these rules based on the grave danger and the new standards that's necessary to protect, individuals. So there's lots of, notions that the government has overreached here, and that is kind of what is obviously being challenged in court. So again, in the meantime, our suggestion would be for employers to put everything in place and start getting all the puzzle pieces together so that you're not rushing and scurrying to try to put this together at the end of the day when we get close, especially knowing that the holidays are approaching and a lot of offices and employers shut down for at least a couple of days around Christmas. And you don't want to be getting to that point where your Christmas and New Year's and you have to try to figure this out while, you're working on a long weekend where there's a holiday and nobody else is. So I know that was a lot to say. Kevin, do you have any other kind of closing thoughts to leave our listeners with?
Nope, just that, it'll be really interesting to see what happens, obviously with the current litigation going on, everything like that. So we're going to keep our eyes on that and be really interested to see what the next steps are.
Right. At this point, again, like I said before at the beginning, I'll wrap it up and say full disclaimer that we are operating on the information we have as of right now while we are recording this. And unfortunately, with how quickly things are moving, this could be a little out of date by the time it gets posted. But hopefully this will give you a good basis of knowing and understanding these rules, since this is a very hot topic. So thank you for joining us and have a wonderful holiday season.
Thank you very much.